Now, the other interesting thing, though, that a lot of people forget about, and again, as an advice lawyer, I tell self-represented litigants about this all the time.
Yeah.
The family law rules do say, and again, it's specifically set out, Rule 2410A. The rules require the court to make a summary determination as to who is entitled to costs promptly after each step in the case and to set the amount. So like I said, for example, one of the interesting disputes that's going on, and there's cases going both ways in Ontario right now, is about if people have filed all their documents and served what they need to do, and they're scheduled for a case conference, and they attend at a case conference. Can you actually ask for costs after a case conference? And decisions go both ways. And generally, it's pretty safe to say that if you show up at a case conference and you're not prepared, you haven't done your documentation and you're not ready to proceed, so you're that unprepared litigant, the party right if the case conference is going to be adjourned because the other party is not prepared to proceed, the party that was ready to proceed should immediately ask the judge to make an order for costs of the case conference and ask for an amount to be set and that it be ordered against the other party, or even if the judge isn't prepared to do that, to ask if the judge would be prepared to say the costs are to be reserved so that it can be brought back and argued another day, because this might have been just a one-time thing. Now the party is saying, holy crap, I could end up getting in trouble for not being ready. I'm not going to do it again. And they straighten up and they do what they're supposed to do at the other stages of the proceedings. A judge may not order costs for the case conference, but they can. But let's say that you're going into court on a motion. It's a very serious argued thing. The parties cannot agree after separation which parent is going to have the children living with them on a day-to-day basis and where the kids should be registered for school. Once that motion is argued, the successful party on the motion immediately, when the judge renders a decision, somebody's going to be the successful party, one is not. Then the successful party should be asking the court to make an order for costs right then and to set what that amount is. But again, always the court can either say, no, this was a legitimate issue. It really needed a judge's input because these parties were obviously not going to be able to settle. Again, if one party has made an offer to settle and and if the other person had accepted the offer, the outcome was as good or better than what the party actually ended up with after arguing it, that's a pretty good basis for saying there should be costs, because these parties could have made this thing go away without ever having to engage the court or the court's time. But other than those situations, then again, the general rule is successful party on a motion should be asking for costs as soon as the motion is heard and getting the amount fixed. And the costs can change. Like again, once you get costs, you might be successful on a motion after your first case conference and get an order for costs. Then you could be 8 months later in on another motion and you lose that motion. You could be the one then is made to pay costs for that motion, but it doesn't change the costs order from the first motion. So they don't necessarily offset each other. Like the courts will not generally say, well, you were successful on that motion and you got a $500 order for costs, but you lost the next one and you were ordered to pay $750 in costs. So that means now the other side only owes you $250. In practicality, that might be what happens, but the courts don't do that arithmetic. An order for costs is an order for costs. And I've actually seen cases where a judge has said to a party, you owe the other side $85,000 in costs. You have to pay the other side $85,000 in cost. And at the same time, other party, you owe that person $40,000 in costs. So you have to pay them $40,000. So they actually make the money change hands.
Huh.
Unless the
Interesting.
parties agree to do the set off.
That is really interesting, but I was going to ask you something. So when you said the parties should ask for costs right away at the end of the hearing, so that means you should go to a hearing with a list of the costs that you've spent ready on hand.
You should be prepared to make your,
Yeah.
okay, that's again, to go what we did offline before we got started, is submissions as to costs. So all submissions as to cost mean is that what are the arguments you're making before a judge as to why you should be entitled to costs? And if you are, what is the amount that you're entitled to?
Right.
So again, yes, I would always advise people that going into a contested proceeding or a hearing, or even if it's like a case conference and the other side hasn't done what they should have done, start marshaling all the facts and have a checklist, a list that you've written down about saying, I think I should get my costs for today, and this is why. And it can be, this is my job, this is what I do. I had to take 5 hours off work today to be
Right.
here to do this. It took me this time, like 12 hours to prepare for this hearing. I've done everything I'm supposed to do. Again, especially if you're dealing with a matter that is covered under the family law rules, because there are now, like, as far as
Mhm.
financial disclosure goes, because there were so many people that were playing fast and loose with the rules about trying to hide the weeder with playing the financial disclosure,
Yeah.
there's now automatic orders. So if you can show that somebody has failed to produce the financial disclosure that comes out as required by an automatic order, you should be pretty well guaranteed to get some
Oh, wow.
costs. But how
Mm.
much costs, again, depends on the different factors. Did you do everything you were supposed to do? Do you have a lawyer? Did you have to pay the lawyer to come? And your lawyer should have a bill of costs ready to go.
Yeah.
Yeah, so it's just, again, what the courts are trying to do is to hold that stick as opposed to a carrot over people's heads and say, you are expected to be reasonable. You are expected to do everything you can to move the case ahead. You are
Mhm.
expected to follow the rules and produce the disclosure required to do. If you don't, there's a whole pile of things that the court can do to you. One of them is they can make you pay the other side money because you've wasted everybody's time. How much you're gonna have to pay depends on how bad the behavior is. If the other side can convince a judge your behavior has been so bad, it takes it over that bad faith threshold, you might be required to pay an awful lot more in costs than you might have if you were just trying to be reasonable. Yeah.
Just one last question. If you're a self-rep and you have no experience in this and you forget to ask for costs, does a judge ever, out of their own initiative, order costs, even though you don't ask for it? Like, my point is that
No, that is something that is very, very, very rare. What a judge might do, and I have seen them do it, is just say, well, Mr. So-and-so, you were the successful party on this motion. Do you wish to make submissions about costs?
I see. Yes.
Just hint, nudge,
Hint,
nudge.
hint. Yeah,
Do you
got
wish to
it.
ask, do you wish to make submissions with
I
respect to
see.
costs? And if the
Got it.
person just
Okay.
says, no, what, I don't have a lawyer, it's okay. The judge is not gonna argue with them or say, well, I think you should get your costs and I'm gonna make an order for costs. No, it
Yeah.
doesn't happen. I don't think.
Right.
I've never seen it happen.
That's very almost like partial. Like it's almost taking sides. Yeah. Okay.
Yeah, well, again, the judge's job is not to advocate for either party. All they can
Right.
do is
Yeah.
if they really feel it's because the person doesn't know the rules, there's a gentle judicial nudge that they can give about saying, well, you're the successful party. Do you wish
Right.
to make any submissions with respect to costs?
Interest.
A
Okay.
lot of judges won't even do that. They'll just keep saying, nope, if the party doesn't ask, it's not my job to make them think in that direction.
That's
So,
true. Okay, sorry about that. So sorry, David. That's
no,
all my interruptions.
no, well, they're good because these are the kind of things like people need to know about before they go into court. So it does
Right.
happen.
Yeah.
Okay, now the other interesting component and why I really like Rule 24, it even goes, there's actually, I think this is under a different rule actually, but it engages the cost consequences at Rule 12, sub 3.
Hmm.
And that's like Rule 12, it goes through the stuff about what are the pleadings that need to be done in order to legitimately get a court case rolling and started and carrying on.
Right.
And Rule 12 is really, really interesting because under Rule 12 sub 3, what happens if somebody starts a court proceeding? Gets it all done, issues it, serves the other party, and all of a sudden said, oh no, this is not going the way I was expecting it to. I don't even want to do this. I'm going to withdraw my
Right.
I don't want to, I'm withdrawing. I want to stop this whole court proceeding.
Right.
And Rule 12 says if a party withdraws all or part of an application, an answer or a reply,
Yeah.
then that party shall pay the costs of any other party concerning the withdrawn application, answer or reply, up to the date of the withdrawal.
Right.
So if you've started a court proceeding and then decide you don't want anything more to do with it and you want to withdraw it, you could be responsible for paying costs to the other party for any costs they've incurred to get up to the point right where you serve the notice of withdrawal. So you can't just say, that's fine. I didn't mean to do it anyway. I'm just going to withdraw it and it's all over now, because no, there still could be potentially cost consequences.
you said potentially. So does this mean that if the other parties don't chase after you, then you can escape? I mean, like, what if the other parties just kind of like they're too busy to pursue, what they're entitled to? Then can you just let? Can you? Are you then let
You,
go?
you should every step of the proceeding, every time something happens in family court,
Yeah.
saying, is the other party taking a reasonable position or not? Should we be able to settle this or not? Should I be serving an offer to settle? Am I being reasonable? So every time you're looking at going into court, that's the whole reason Rule 24 was put into place, is to make parties think, what do I want to accomplish? And do I really think this is worth bringing to court because I think I'm going to win? Because knowing if I lose, there are going to be cost consequences. So you should be thinking about that every step of the way. But again, it's like like Rule 12, just say if a party does withdraw all or part of an application, then the party shall pay the costs of every other party concerning the withdrawn application. But again, a court's not going to make the innocent party aware of that necessarily. So yes, it should be up to the litigant to always keep in mind, should I be asking for costs at this point or not?
Wow.
Should I be asking for costs or not?
Wow.